Thank you for joining us. Today, we're going to talk a little bit about the L-1 visa and how to transfer a manager or executive or intracompany transferee to the United States. A few things before we get started. Scott Legal is a full service immigration firm. We focus on business immigration and also work in areas of family immigration. So please reach out to us for any of your immigration needs. We will continue our webinar series, doing at least 2 webinars a month on various different immigration topics. At the end of this webinar, you'll get a few things. One is the PowerPoint that you see here. Another is a comprehensive guide to the L-1 visa, and also a link to where you can sign up for additional webinars. My name is Kelly Weiner. I'm the managing attorney at Scott Legal and have extensive experience processing L-1 visas. And I will be guiding us through the PowerPoint today. If you have questions, please send them to the chat box. And finally, this webinar is being recorded and will be made available on demand and is also available or will be available on our YouTube channel where we have many videos where I encourage you to subscribe. So we will now move on to start the presentation. So let's look first at the L-1 requirements. So the L-1 visa allows companies outside the US to transfer employees to US companies that they have a qualifying relationship with. So let's just walk through those, basic requirements. So first, there does have to be a qualifying relationship between the company abroad and the company in the United States. This can be a parent, affiliate, branch, or subsidiary relationship, and there are specific definitions for this in the regulations. So it's important. Even if perhaps you consider the company's affiliates, it's always important to kind of speak with an attorney to understand what do the actual corporate documents say. Will they qualify under the definitions in the immigration regulations. So another requirement is that the companies abroad in the US have to be actively doing business. So this is defined as the regular, systematic, and continuous provision of goods and services. So if one company has a corporate entity but is not actively trading, providing any goods or services for revenue, then that's going to be problematic for the L1. The one caveat or exception to that is if there is a U.S. company that is just being started, what we call a new office, then it doesn't need to be actively trading or doing business yet, but there will be some additional requirements that you'll need to meet in order to send over an employee to start up that new office in the United States. So the other requirement when we look at the employee is they have to have worked for the company abroad for at least 1 year out of the past 3 years in an executive, managerial, or specialized knowledge role. So you have to look both at the time that they've worked for the company, and you need to consider what have they been doing for the company? What are the specifics of their job? So for the L1A, this is going to be for managerial or executive employees. There's very specific definitions in the regulations about what counts as a manager or executive. So again, important to discuss with an attorney because you will need to provide kind of very detailed job descriptions and job descriptions that show that there is an alignment between the regulatory definition for these roles and what the person has been doing for the company. If you are getting an L1A, then you can continue to kind of renew the visa for up to 7 years total. After that, you would need to find, another visa status or depart from the United States. For the L1B, this is for applicants who are coming to the United States to fill a specialized knowledge role. Again, very, detailed, definition of what counts as a specialized knowledge employee. So, very important to be able to support that argument that this person really qualifies as a specialized knowledge employee. And people coming in this role can renew their visa for up to 5 years. All right, so let's talk a little bit about a new office L1 application because this looks a little bit different than a normal L1 application. In maybe what we call a normal L1 application, both companies perhaps have been doing business for many years. They're transferring someone, but there's also situations where somebody has, a company wants to start up an office in the United States, and in that situation, then there's some additional requirements that you need to meet. So a new office is defined as an organization which has been doing business in the US for less than a year. So that's the situation for less than a year. If you're starting up a new office, so either, you've incorporated or, you've just barely incorporated, then you will need to include this additional evidence. So one is proof the company has secured sufficient physical premises to house the new office. Um, the other is the employee, an employee who's coming to the U.S. Under a managerial or executive role has to show that there's going to be employment planned for the U.S. new office that's going to support this managerial or executive role, within, 1 year. Um, and along with that, you have to show kind of that there's the scope, um, scope of the office, the organizational structure, the financial goals, the size of the U.S. investment, financial ability of the foreign company to pay the employee and start the business in the U.S., and the organizational structure um, of the foreign company. And these are all important just to help the government feel comfortable that there's actually a viable plan to get the U.S. office started, and that the person who's coming to run that new office is going to qualify under the regulatory definition of employee of a manager or executive. For an L-1B, new office petition, uh, you have to provide proof that the company has secured sufficient physical premises to house the new office, and that the petitioner has the financial ability to remunerate the employee and commence doing business in the U.S. So there's a little bit more of a, kind of much more common, I think, for companies to send over a manager or executive. Um, and because of that, there's a few more requirements. Um, so let's talk about the L1A definition of executives and managers. So as you can see here, executive capacity and managerial capacity are defined, very specifically. An executive is someone who's going to direct the management of an organization or a major component or function, establishes goals and policies, exercises wide, latitude and discretionary decision making. Um, and receives only general supervision from kind of higher level executives or perhaps from a board of directors. So when you are, it's not enough to kind of put this definition into the job description and say this is everything they do. You really need to provide specifics. What are some examples of times when they have established goals or policies? How do they direct the management of the organization? Very often they will want to see, if you're directing the management of an organization, that means that you are overseeing managers who are doing the day-to-day work. So very important to kind of, explain all of that in the letters that you'll provide, explaining the job duties, and then as well to back that up with objective evidence. So if you were the CEO and you wrote kind of the policy manual, or firm policies, that's something that you could provide as evidence that you have held an executive role. When we look at managerial capacity, so this is, someone who manages an organization, supervises and controls work of other supervisory, professional, or managerial employees, or manages an essential function. So here's where, somebody who is managing first line employees, may not qualify. If you do have to demonstrate, who are you managing? Do they have, degrees? What roles do they hold within the company to see, to show that you meet this requirement? Also need to show authority to hire and fire, recommend other personnel actions, exercise, discretion over day-to-day activities. One, kind of thing that is important to point out here is that you can be a personnel manager. So that's, I'd say the more normal, way that it goes, where you're going to have kind of multiple, professional or supervisory employees under you within the hierarchy of the organization. But you could also be something called a function manager. So this is where perhaps you don't have a huge number of employees working under you, or maybe you work in a kind of specialty, smaller department. But within that department, you manage a very essential function, for the company. So for somebody who is, more appropriately classified as a manager than as an executive or specialized knowledge worker, but, manages a function as opposed to managing people, that's a potential option that can be explored as well. So let's talk about specialized knowledge. So specialized knowledge, means special knowledge possessed by an individual, of the company's product, service, research, equipment, techniques, management, or other interests in its application in international markets. Or it could also mean an advanced level of knowledge or expertise in the particular organization's processes and procedures. So in either case, you need to demonstrate that the knowledge is not commonly held throughout the industry. So, I'd say the specialized knowledge category is not a catch-all for anybody that wouldn't qualify as a manager or executive. In fact, it can be quite difficult to prove that you meet this definition. You don't have to have, when we look at special knowledge, you don't have to have proprietary, knowledge that nobody else has. It certainly would help, perhaps if you do, but you do need to meet this, this requirement. You do need to demonstrate kind of this advanced level of knowledge, or this special knowledge, show how this knowledge that you have will help the company in its competitiveness in the market, increase its financial position, service clients in a particular way. So there does need to be some, explanation of this, and explanation of why the applicant themselves, the employee themselves, has this knowledge that is not commonly held, that could not be found in the United States easily. All right. So what documents need to be submitted? So if you're applying for an L-1, as an individual case, there are something called L-1 blankets, but we won't kind of discuss those. Those are specific to kind of companies that are very large and meet certain requirements. But for a general L-1, individual application, you'll need to submit a form to U.S. Citizenship and Immigration Services. This is on Form I-129. And then you submit supporting documents. So this will include corporate documents showing the qualifying relationship. So, let's say you have a company abroad that owns the company in the U.S. 100%. You would include the incorporation document, and then the proof of that 100% ownership. You want to also include proof that each company is doing business. So tax returns, audited financial statements, payroll, any documentation, particularly documentation that's been maybe submitted to the governmental authorities, is helpful to show that the company is actively doing business. You also want to include proof the employee worked for the company abroad for that continuous year out of the past 3 years. So, most commonly this is going to be kind of pay stubs, payroll records. If there's been kind of some other type of arrangement, perhaps somebody is, a director, they're paid through distributions. That's okay as well. Again, as long as you can just show, that they did receive that income, or that they were an employee for the business for at least that last year out of the past 3 years. And then you also need to include proof that, they held a managerial, executive, or specialized knowledge role abroad. So, those definitions that we were just talking about, you need to include proof, most commonly that's going to take the form of, a letter signed by, somebody in senior management at the company outlining the job duties, but then also supported by objective evidence, perhaps work product, that demonstrates that, what you've outlined in the letter, is actually how things run at the company. And then finally, you need to include proof that the employee's role in the US is going to qualify as a managerial, executive, or specialized knowledge role. Again, you can include the written job description, organizational charts showing the hierarchy within the company, internal company documents or memos. And also an important thing to note is that you don't need to be coming to the US to hold the same role that you held abroad. So if you were a manager abroad, but you're being sent to the US for a specialized knowledge role, that's fine, that's possible. But then it means that in each, job description, job letter, you're going to have to really outline how you met the requirement for the role abroad, and meet the requirement for the new role in the United States. All right, so requests for evidence. So requests for evidence are extremely common for L-1 petitions. Data shows that over 50% of L-1s, will receive requests for evidence. Very often they will challenge, does the applicant meet this definition of manager, executive, or specialized knowledge worker? And then you're in a position of maybe needing to submit more evidence. That's where, as we discussed, the objective evidence, so not just the letters of the senior management stating that this is how things work, but actually supporting that with work product, supporting that with, corporate memos or documents that show that, that what you're stating in the letters actually has a basis, in reality. So that objective evidence can be just, I think, a really, really key part of any response, to any request for evidence, because, prior emails, anything that really shows, for example, if you have emails showing that, a manager exercised that authority to hire, fire, recommend personnel actions, all of those things can be very helpful to support what's in the letters. All right, let's talk about timing and dependence. So the way that the L1 works is, first, the petition that's submitted to USCIS must be approved. If you're doing normal processing time, it could be several months. The company can also choose to pay an additional $2,500 for premium processing and get a response within 15 calendar days. The response could be an approval, a denial, or a request for evidence. If it's a request for evidence, then you'd submit a response, and then 15 calendar days after they receive the response, you'll get a decision. They could also potentially issue a second request for evidence, although that's less likely. After the L1 petition is approved, the employee applicant will schedule an appointment at a U.S. consulate abroad and go to get the L1 visa stamp in their passport. If they're already in the United States, an invalid non-immigrant status, let's say they entered maybe on B status, for a couple weeks on vacation or something, and then you do this as a change of status, then they could change status to L1 from within the U.S. Spouses and unmarried children under 21 can accompany the L1. They come on L2 visas, and the spouses of L2 visas are allowed to work. Children can attend school, but unfortunately cannot work. So a very common question is, does an L1 lead to a green card? And, there is a green card category. There are a few green card categories that are potentially available for people on L1. So the L1A, if you held an executive or managerial role abroad, and you're now coming to the U.S. to hold a managerial or executive role, then the EB1C multinational manager or executive green card may be available to you. Similar requirements to the L1A, but it is a green card. It's permanent, allows you to stay in the U.S. Forever. So there is a heightened standard. So when we look at these requirements, there has to be this qualifying relationship. Both companies have to be doing business. U.S. employer has to have been doing business for at least a year. The employee has to have worked as a manager or executive abroad. So if they were holding a specialized knowledge role abroad and now they're coming to the U.S. to be a manager or executive, unfortunately, that's not going to work for the EB1C. The benefit of this is you can avoid, for many of the employment-based green cards, you have to do a labor certification. There is no labor certification required for the EB1C, but however, the standard to show that you are a manager or executive, again, can be quite hard to meet. If you have a very small operation in the United States, or even if the operation abroad was very, very small, they will look back and see, do we really think this meets the standard? And even if you got an L1A approved, it's not necessarily going to qualify for an EB1C. Generally, you do want the company to have, a significant amount of personnel, a developed operation, to help support the argument that, you qualify as a multinational manager or executive. If you're coming as an L1B, as mentioned, if we're in a specialized knowledge role abroad, or you're holding a specialized knowledge role in the US, then you wouldn't qualify for the multinational manager or executive. You would need to qualify under another green card category. One popular option is called the PERM. This is where the company, the U.S. employer, it will sponsor, the employee for a green card. They have to go through a labor market test where they actually, put out advertisements, interview any applicants that seem, willing, qualified, and available. And if they do find any willing, qualified, and available U.S. workers for the role, then the process has to stop. If they don't, then they'll submit the labor certification to the Department of Labor. And if they get approved, then, they can proceed with the green card process. They would provide evidence. The company provides evidence that they have the ability to pay a prevailing wage. The employee provides evidence, that they meet all the requirements, the specialty requirements for the job. And that's another path for a green card, and, could be available for somebody on an L1B specialized knowledge role. People often think about the L1 when it comes to a green card, because the L1 is what we call a dual intent visa. So this is where If you're in the US on an L-1 and you also have a green card petition pending, there's no issue with that. There are some visas like the TN visa or the F1 visa that have very high standards for non-immigrant intent. This means if you have a green card petition pending or you indicate you want to move to the US permanently, it would be difficult to qualify for those visas. However, for the L1, there's not that concern. For the L1, it's completely fine to have a green card process ongoing while you're in the United States. So many people think of the green card when they think of the L1. All right, so that was the end of our presentation. So I think it looks like we don't have any questions, so we will end there. I hope everyone has a wonderful day. Thank you.